I certainly invite Professor Bajpai to have few words before we begin the panel discussion. Sir?
Thank you. Actually, I'm just here just to welcome you. And I'm very glad and I can acknowledge the presence of Mr. Tejas, Mr. Rohit, and Mr. Gauhar, Mr. Kevin, and of course, Mr. Prakhar, who is the coordinator of this event. Friends, I have taken over just 1 month and plus few days ago to this university. And just to tell you by way of my initial remarks, this kind of activities, I have set up my priorities in terms of always being open to have this kind of discussion more and more. And of course, these discussions will definitely provide a much needed exposures to the students who are willing to take up their later careers in different fields. So I really wish that the practitioners from all the organizations, they are always invited and to become the part of this. And I also take this opportunity to please give your critical feedback to the instructions that we are imparting, especially in the field of ADR. And this university is particularly organizing a range of activities through different centers and through different panels in this university. So we will be very soon launching a couple of our initiatives in ADR and all other fields where I would be really looking forward to your active support and participation. And in times to come, I am hoping that when the things are really resumed and COVID situation is, just declined a bit, and then we can probably try to have some interaction in a very physical mode to this university. And we are looking forward to that opportunity very keenly. And there we'll have the opportunity to invite Prakhar and all the people who are sitting here to be the part of this. And I also take this opportunity. We are also contemplating some applied courses in the area of ADR, where certificate programs or training programs. We have already launched a couple of initiatives. I was not prepared for this meeting today. Otherwise, I would have really pinpointed some specific initiatives that we are intending to undertake. So I feel that this process of consultation with the practitioners must go on, and that way this university will become very vibrant place for bringing academician, practitioners, and learners together. And I'm hoping that this blending will become very, very significant in times to come. And also, please do suggest that what kind of courses we can start for practitioners, because I have recently launched a very robust training initiative within the university, especially involving the stakeholders. I have spoken to the government and different partners to be the part of it. So I'm hoping that we can resume this conversation sometime on a different platform. Today we are meeting for a panel discussion, so probably it may not be the right platform to really discuss all those things. But we will soon find an opportunity. I hope Prakhar will again coordinate this conversation. We have to take this conversation ahead. And so I'm looking forward to your cooperation and involvement and participation to enrich the ADR culture and plus other initiatives on this university. So once again, I thank you all for joining this panel today, and I'm looking forward to a very meaningful discussion on this particular issue. Thank you. Over to you, Prakhar.
Thank you, sir.
Thank you so much, Professor Bajpai. We really look forward to have a discussion on the future aspects. So moving on to the panel discussion for today, the first topic is regarding the qualities of an arbitrator. So my first question is to Mr. Tejas, that while advising clients on selection of an arbitrator for a particular dispute, what are the key qualities you look for when choosing an arbitrator?
Thanks, Prof. Prakhar, for that very, very interesting and practical question. But before I start answering, I want to thank Professor Bajpai and RGNUL for organizing this conclave and being head of the arbitration of Shardul Amachan Mangaldas. I'm very happy that we are partnering with one of the top NLU on the practical aspect of arbitration, because what we see is that theoretically it's always possible to teach students and guide them, but when they start practicing, and when they come to us in a law firm or they start their independent practice, we realize that they start learning the aspects of arbitration practically. And all this conclave will really help students and the participants to understand what are the nuances of the practical approach of the arbitration. So I'm looking forward to many more such opportunities to partner with RGNUL, and we would really be happy to assist in whatever way it is possible. Now, coming to the question on selection of arbitrator. This is very, very crucial aspect, because the arbitration is as good as the arbitrators. And if we go wrong in identifying the arbitrators, we may not be successful in the arbitration, because one of the virtues of arbitration is that you can select your own arbitrator. It's a party autonomy, which makes the arbitrator selection a very important aspect. Now, when you are faced with a situation, and many times clients ask us that whom should we nominate? So we need to keep it in mind various aspects while selecting an arbitrator. The first one is whether it is a 3-member tribunal or a sole arbitrator. Secondly, where is the seat of arbitration? Because of, I'll come to the various aspects relating to each of this. The third and very important is what is the governing law of the arbitration, and who are the parties, like which are the jurisdiction of the parties. Are the both parties from the same jurisdiction, say Indian parties, or one is US entity and the other is Indian entity? And also, is there an ad hoc arbitration or institutional arbitration? All these aspects are very important, and in each one of it has its own significance. One is seat. So if you are selecting an arbitrator who is permanently stationed or resident of a seat, then you are saving a lot of time and cost in terms of traveling. Governing law is also very important, because we need to understand that the arbitrator has the training and experience in handling the arbitration of that particular law, because if the substantive law of the contract is of a jurisdiction which is of common law, and you get a civil law arbitrator who is trained in civil law, you may not be that successful, or the arbitration may take a slightly longer time. In terms of institutional and ad hoc arbitration, again, institutions have their own procedure for appointment of an arbitrator. So sometimes it's always better to select arbitrator from the panel of arbitrator of those institutions, or we need to have a arbitrator who is going to be accepted by the institution for confirmation of the appointment. Apart from this, the language also matters, because many times you have parties who are having documents or evidence in different language other than the language of the arbitration. So that is something is important. The next thing which we look at is the experience. There are two kinds of experience. One is the number of years which you spend in profession, either as a counsel or as an arbitrator. And the second is the experience in handling the types of dispute which you are going to have arbitrated. So having a domain expertise or knowledge on that particular aspect, for example, oil and gas arbitration or a construction arbitration, you need to know that the person whom you are going to select has ability to deliver the award in the way it is required, in the sense that the person has knowledge about the domain. You are not teaching the finer aspect of the thing. Of course, you can do that, but if you have a person who has an experience, it always helps. The other aspect is neutrality or the bias, if we want to say. Neutrality can be of a neutral nationality. Many times the domestic laws or the institutional rules require for either the presiding arbitrator or the sole arbitrator to be of a neutral nationality. And the other neutrality or the is more of an impartiality or independence than the parties. You have the IBA guidelines on the independence and impartiality of the arbitrators, and India is one of the only, it's the only country who has incorporated the disqualifications with regard to the independence and impartiality of the arbitration in the schedule of the Act. So we need to also be careful that while selecting the arbitrator, we are not selecting somebody who is either not qualified to be an arbitrator under those requirements of specific law, or generally under the soft law, which is applicable to the international commercial arbitration. Other than that, we also need to see that they don't have prejudice against a particular country or a party, because many times they are perfectly independent and impartial, but they have some bias in terms of dealing with the situation. So we need to be very careful while selecting the arbitrators. And lastly, we need to also know them that they have experience in handling arbitrations, because in large complex arbitrations, we have seen there are a lot of procedural issues. So they should have a training in the procedural aspects of case management, because if they don't, then the arbitration goes to a completely on a tangent, and we don't understand the procedure being handled properly. Of course, if it's an institutional arbitration, we can have a help of institutional rules to bring them, and the institution can provide the support. But in an ad hoc arbitration, it becomes very difficult to control and manage the process if the arbitrator is not firm. For example, as simple as granting an adjournment, or how to prepare the bundles, or how to manage time. These are the aspects the arbitrator must be experienced, or at least have firm views about the case management skills. And the most important thing is also availability. If we go to very busy arbitrators who are not available, the arbitration takes very long time, because of conflict of diaries and scheduling. So the availability also matters a lot. So when we are selecting arbitrators, we take into consideration all these different aspects, and it becomes very difficult to select arbitrators. But if we get it right, the chances of success are always good. We cannot assure the client that by selecting somebody we will win, because that's not in our hand. In our hand, it is only to present a case of our client. But at the end, the right choice of an arbitrator makes a lot of difference in the entire process of arbitration, and also successful outcome for any party who is selecting an arbitrator.
Thank you so much, Tejas. So now my next question is for Kevin. So Kevin, in India, there has been a custom that parties usually prefer a former judge or someone with a judicial background as an arbitrator. However, in international trend, the QCs, partners of law firms, and even professors are now taking a lead in becoming the arbitrators. Since as of now, most of the cases which SIAC is currently handling are from India. So how a trend, so what are the expectations of Indian parties when it comes to an arbitrator in SIAC administered arbitration?
Thank you, Prakar, and thank you to RGNUL and SAM for putting together this conclave. To me, this is the exact kind of conversation that we should be having, and I've had a lot of new thoughts based on the papers yesterday. So very, very happy to be here. In terms of Indian parties, let me start with a practical example of a three-member tribunal, and Tejas touched on it to a certain degree. So consider a situation where you have a Singaporean claimant and an Indian respondent, three-member tribunal. The Singaporean claimant nominates one of the doyens of Singapore arbitration that is well known around the world. And then the Indian respondent nominates a judge that doesn't have that much experience in arbitration. If the institution is called upon to appoint the presiding arbitrator, and that's the default under the SIAC rules, we might appoint an English silk. So immediately when you're looking at the optics of that three-member tribunal, it seems that perhaps the claimant's nominee and the chair might be a bit more aligned. So when you're nominating an arbitrator, you want to think about the voice that your nominee is going to have in a tribunal, and certainly all of those other qualifications that Tejas has outlined. And it also goes to the concept of what exactly is a party-nominated arbitrator? What is the role? The Chief Justice of Singapore has an outstanding article on the role of whether a party-nominated arbitrator is an advocate, an adjudicator, or somewhere in between. And in that article, which of course I agree with, is that a party-nominated arbitrator, you are selecting them because they have an openness to your case and to your story. But once they're appointed, they know they owe no particular duty to the nominating party. So that's why you're choosing your nominated arbitrator, because they have an openness to your case. Now, when we're called upon to make an appointment in that same case, we want to look at the optics of both sides as well. What kind of arbitrator will both sides look at as being fair? So not just the sector experience, familiarity with the laws, the seat, we want to look at what would the parties think. So in that situation, it might actually be more appropriate, say, to appoint a Malaysian party, a Malaysian presiding arbitrator who understands the business culture in Singapore and India to a certain degree. And as you say, because we have so many Indian parties in SIAC arbitrations, we are often appointing arbitrators where you'll have an Indian party on one side and then an American party or a party ASEAN from the other side. So we try to strike a balance. So not only all of the formal qualifications, but also an arbitrator that will be perceived to be neutral.
All right. Thank you so much. That was really intuitive. Now, the second topic, which is something which I really want to bring in notice to the panelist, is inflated and frivolous claims. And we come across in many arbitrations that there are, the claims are highly inflated, and by the times the parties proceed to final arguments, sometimes those claims are dropped, and these claims are essentially pressure tactics. So my question to now, I'll go to Rohit. So Rohit, you have witnessed a lot of construction arbitrations, and you have witnessed as an expert witness as well. How often do you see that claims are really inflated and exaggerated in these arbitration? And what's your take on that?
First of all, thank you, Prakar, for inviting me for this panel discussion. I'm really glad that I'm going to speak in front of RGNUL, which is one of the prime colleges and universities related to law. So you rightly said, in construction arbitrations and construction disputes, there is a kind of a tendency, especially amongst Indian parties and Indian contractors, that they should make their claims at least 2 times, 3 times, because then they think that, okay, if we are going to raise a claim of, let's say, $100 million, probably we will get $50 million likewise. But, when we go and advise these parties, we are always telling them that inflating the claims is completely an incorrect, approach towards the arbitration, because then what happens is you are kind of, losing the credibility in front of the arbitrators. For example, that there has been no, there are no actual evidences or documents to prove a particular claim, for example, loss of profit or something, and still you try to say, okay, my total actual damage is maybe $1 million, but my loss of profit is $99 million. So that makes absolutely no sense. Therefore, the general tendency, especially in Indian, construction parties or construction people and industry, is to inflate the claims. But when you go outside India, and then when you go to SIAC and ICC kind of or LCI kind of arbitrations, because a fee is very, kind of proportional to the value of the claims. So there the parties are slightly more particular, and they are, more cautious in putting up the numbers, because they would like to, ensure that the numbers which they are putting for their claims and counterclaims are right, because otherwise they end up paying higher values towards the fee of the institutions. But definitely, one thing is there which we as experts advise is that at the end of the day, when you put an inflated claim, you are not going to fly through that claim. You're not going to be successful in that claim. There is an incorrect, tendency that having a higher claim means that maybe upon, put a discount factor and you'll have that value as agreed by the arbitration panel. No, they are going to look at all the evidences and facts. And unless the claims are not supported, there is no point in putting up the inflated claims. Thank you.
Yeah. So taking that from Rohit, so Tejas, I wanted to ask, as per now, the Schedule 4 of the Arbitration Act has a ceiling of the fee, because beyond a certain point, it's capped. But today the claims are so high. So do you think that if there is a mechanism which can be introduced to counter these inflated claims by introducing some charges, just like a court fee that we have in India, so, to resist parties from making inflated claims in domestic arbitration, do you think that some mechanism may work and help down to curb these inflated claims?
No, absolutely, Prakhar, because what we see in practice is that the parties don't have the calculation of the damages at the very beginning. They just put whatever comes to their mind, if I say so, and then they make inflated claims, thinking that at least we will get 50% of that. And that is totally misconceived notion, because arbitrators don't give on percentages. They give award on the basis of the proof, and the quantification has to be proved either by the parties or by the experts. So these inflated claims have to be stopped, and many times what you get is that instead of 50%, you end up getting nothing because you have not been able to quantify the claim which you have made. In terms of fees, you're right. We need to have some kind of a linking with the claim. If you see any institutional arbitration, they have ad valorem fees. Rather than having any cap, they have the fee calculator. For example, SIAC has a fee calculator. You put the claim amount and you get the estimate of the fees. And that is what we should have followed rather than capping of the fees, because that is something where you can really stop parties from making any claim which they like. Because in SIAC, many times what has happened is that once SIAC sends the advance fees request, some of the parties have amended their claim and counterclaim and reduced the claim amount. So that is how parties realize that, okay, this is not the worth fighting for this, because if we end up paying the arbitrator so much, what are we going to get out of it? Because parties really know their case. They even though they pretend that in statement of claim they make any case, but at the lawyers and the experts, they know their case. So that is one aspect. The other aspect is actual cost. Now we have added the regime of section 31A, which allows the tribunal or the court to grant actual costs. Up till now, we were getting very nominal cost in domestic arbitration. In international arbitration seated outside India, we used to get actual cost. But in India, we never used to get it. So that is something, again, the tribunal should get into at the end, all the parties for fee submissions and also the proof of the actual cost which they have incurred during the arbitration process or any related litigation. And also apportion the cost depending on the outcome of each of the stage of the arbitration. For example, you may win the arbitration, but if you have made an unsuccessful application for interim measures, why should the cost should be paid by the other party? Because you bring an interim application and you are unsuccessful for that particular aspect, you should be paying the cost, and that should be deducted from the total cost. So that kind of cost management we need to do, and early cost management is very important aspect. There are jurisdictions where you have that kind of early cost management, or there are cost schedules which are provided by the institutional rules, which has to be kept in mind. So we can adopt that. Indian institutions are also adopting that. We have SIAC, ICC, LCIA, they have the proper cost regime. And many times we have to really follow the actual cost basis to stop these inflated claims, because otherwise you may end up having the claims which you don't get it, and the arbitration gets prolonged just because you are not serious with regard to quantification of the claims.
Certainly. I think if we link and there is some amendment which is brought in to just remove the capping, then we won't really see the claims which we see in India of thousand crores. So now moving on to the other aspect, which is delay in arbitration proceedings, and I mean, we witness it even after the amendments and the rule that the arbitration has to end within 1 year or 18 months. We still see arbitrations lagging. So my question is for Gauhar, that the Arbitration Act has a provision while extending a mandate under Section 29A(5), and we recently did a case in High Court and the Supreme Court where we, agitated and argued on the aspect that courts should take some proactive measures while extending the mandate of the tribunals. But we really did not come across any jurisprudence as of now where courts have put conditions on the tribunals. Do you think that because of so many delays, it is time that courts need to exercise this power under 29A(5) of the Arbitration Act?
Thanks, Prakhar. Firstly, I'll thank everyone, RGNUL, for having us. And I have been a very instrumental part with RGNUL. I used to come there and teach them arbitration, but now we have COVID, so we can't do it anymore. But now to answer the question that Prakhar has put to me, in my personal view, of course, we did a case recently. But in my personal view, yes, there has to be some amount of court intervention to avoid the delays that are occurring, and also that particular section that Prakhar referred to, 29A(5), there is no jurisprudence or no development on that aspect. In my view, if of course we are moving towards a time where limited court intervention is required and arbitration has to be the first choice for every party. But what happens when the arbitral tribunal is not acting in the interest of the party? Then court has to somehow look at it. Court has to intervene at that stage and avoid it. For example, there is a delay. If there is a delay being shown to the court and a reason is being given, so the court should impose some amount of either cost or some amount of deterrent, where arbitral tribunals will, of course, gear themselves up to avoid these delays that usually occur. In my view, in my personal view, of course, we'll have to still test these things in court, and we have not been able to yet. But yes, there is a requirement that courts have to have some amount of intervention or some amount of supervision over these processes to avoid inconvenience to the parties. Because ultimately, what is arbitration? It is for ease of parties. Otherwise, everybody could be in court and there can be delayed processes. So in my view, yes, there has to be some amount of court supervision.
Certainly. So when it comes to delay, my next question is again to Tejas, that in today, especially Delhi High Court, what we experience is very efficient. You file a Section 9 petition for interim measures, and the next day court hears it and usually get a relief. But in terms of ad hoc arbitrations, it is still a distant dream for us because of the delay and because of sometimes non-responsive from the tribunal. So how do you think what can be done? So, because I understand that, Section 9 is there, but Section 17 is becoming redundant because parties are approaching the court. So what do you think is a solution to this problem that, tribunals, that parties should now go to tribunals instead of court? Is there any solution to this issue?
The solution is very simple, and we missed the bus twice in 2015 and 2019 of recognizing emergency arbitrators. Although in our committee of law commission, we had strongly recommended recognition of emergency arbitrator, and in 2019 it was reiterated, but somehow we have not put it in our act. Nonetheless, we have now some decisions of Delhi High Courts and other courts in India where they have recognized the emergency arbitrator. You are absolutely right. When we go to Delhi High Court, we can get an interim relief in 2 to 3 days. But those interim relief, if you compare with emergency arbitration, Section 9 continues for almost 3 or 4 months, whereas emergency arbitration comes to an end within 14 days. So it's such a great tool, and you talked about ad hoc arbitration, but why are we still going up for ad hoc arbitration? We need to go for institutional arbitration. All of us in future, as and when we draft our arbitration agreements, it has to be institutional arbitration. You may select any institution of your choice, but it is a very important tool to avoid going to court, because once you go to court, listing is easy, but disposal is quite difficult, and that takes a lot of time. Secondly, confidentiality is gone, because the moment you go to court, all your cases in public domain, and there is no confidentiality which can be there. And plus, against 9 you have an appeal, whereas against emergency arbitrator, it is treated, if it is treated as 17, it is an order of the court. That will be a deemed order of the court. It will be enforceable order, and then again you can have an appeal, but you don't have to always go and file an appeal because it's not necessary. So that is something which we should definitely implement in all our arbitration, is to have institutional arbitration. Mostly all institutions have the provision of emergency arbitrators. So even if the Indian Act doesn't recognize, we can go for institutional arbitration, and instead of going to court under Section 9, we should go to emergency arbitrator.
Thank you so much. So Kevin, SIAC has played a very instrumental role in in settling the disputes in record time. So I was reading a report that the average time taken to, complete the whole arbitration process in 1 or 1.5 years in SIAC. So wanted to know from you, how is that something that, is it because of the strict timelines, or it is the way the tribunal is constituted? What is the keys of success of SIAC when it comes to resolving the issues in such a short time?
Thanks, Prakar. I will start with a lawyer's answer and say that it's both. It's the strict timelines under the SIAC rules, but it's also getting the right tribunals appointed. Tejas alluded to this earlier on. If you want to have an efficient arbitration, the best way to do it is to get a really good tribunal and be able to marshal the proceedings. The institutional role is actually interesting to a certain degree, because you have to balance how much you can push an arbitration. But one of the reasons why you want to choose institutional arbitration is that there's a referee there when timelines start to slow down. If you're in an ad hoc arbitration, and if you're a claimant that is waiting for your award from a tribunal, you may not be too inclined to push this tribunal while the tribunal is deciding on the merits of your claim and say, hey, where is this award? We need this award. That's where the institution is effective. Ad hoc arbitration is great if everyone is cooperating and you have sophisticated counsel on both sides and an eminent tribunal. But where you need the institution is when things might go a bit sideways or to manage the timelines. And so the starting point for SIAC are those timelines under the SIAC rules and how quickly the institution is able to act. We hear stories out there in the arbitration ether about institutions that will take 6 months to appoint, or a jurisdictional objection to the institution that will last a year. So one thing that we've prioritized at SIAC, and part of the reason why SIAC has gotten so popular, is because we say that we offer the best case management in the world, but we do it faster and more cost effectively than anything else. And if you look across all of the provisions in the SIAC rules, you can see that all of them are designed to get back to the fundamentals of arbitration. That it's quick justice, it's fast, it's cost effective, customizable, limited avenues of appeal, choose your decider, enforceability, all of these fundamental tenets. That's what all these rules are designed to do. And you can start to see how you can put these rules together, especially for experienced practitioners. So you could have an application for the appointment of an emergency arbitrator, get an injunction, and it could even be less than 14 days. You can get an injunction maybe in 3 or 4 days and then proceed to the constitution of the tribunal. After you do that, you could apply for a fast-track expedited procedure and have an award 6 months from the constitution of the tribunal. Within that, you could make an application for early dismissal. So we were talking about some of these inflated claims. If these claims are outside the 4 corners of the arbitration agreement, within a fast-track proceeding, you could apply for early dismissal to strike out those claims. So everything that we've done is to try to make arbitrations as fast and cost-effective as we can.
Thank you so much, Kevin. So now I want to discuss a very important aspect of the arbitration, which is now coming, which has all, which is the expert witnesses. So, I mean, I want to discuss the role of an expert witness in arbitrations. As you know, disputes can become very technical at times. If you have a dispute of a complex financial transaction or of a construction arbitration, then you need a technical expertise, somebody to pitch in their expert views and to lead the tribunal to a right conclusion. Because as an arbitrator, a person might not be so well versed with the technicality. So now today we are fortunate to have Mr. Rohit Singhal. So Rohit, I just wanted to ask, in international arbitrations, like expert witness is a norm. If you have a very complex claim, then parties are definitely going to have an expert. But do you think that in India, especially when it comes to domestic arbitrations, this trend is still yet to kick off, and parties are not really getting the benefit of expert witnesses in domestic arbitrations in India? What's your take on that?
Thank you, Prakar. So basically, Prakar, first of all, let's take a step back and let me explain what is expert witness. That's something which is quite a confusing concept, especially in India. The role of an expert is an expert is considered to be an independent expert, although he or she is engaged by the parties who are in dispute, but the responsibility of the expert is towards the tribunal and to help and guide the tribunal to come to a right decision, especially on areas which probably are complicated and requires a testimony of an expert. For example, let's say tomorrow if there is a dispute related to medical field, gastroenterology, the arbitrators probably might not be that much experts in the area of gastroenterology. Similarly, in construction, if there is a dispute related to a nuclear power project, the arbitrators might not be experts in the area of nuclear engineering. So there comes the role of an expert, and these are party appointed or at times tribunal appointed experts, but generally, the trend is more for party appointed experts. And the responsibility is to give the right testimony, the correct and independent view to the tribunal. Now, you rightly said that in international, arbitrations, it's a norm. You will every time see that the tribunals during their procedural orders, the first procedural order will specify that the parties are going to bring the experts, and generally the parties are bringing experts. In domestic arbitration, this is still something which is new, and but definitely the trend is kicking in. A lot of the arbitrators who are most of the time retired Supreme Court judges are also actively participating in international tribunals, and they see the role of the experts over there. They see the importance of the experts. So therefore, when they come to the domestic arbitrations, they are open to the idea of accepting expert testimonies. Also, the parties, especially in construction disputes, are now understanding that in case they have a high value dispute, which is complex in nature, and probably, because these are engineering disputes, someone who has got the knowledge of engineering, the knowledge of construction needs to testify and clarify to the tribunal that what is the, dispute all about. So in general, things are improving. I can tell you a lot of arbitrators, are there who are insisting on the testimonies to be provided by the expert. But yes, there is still a short number of arbitrators who have got, kind of, an idea which is averse to the presence of the experts. They sometimes thinks that even though there is this concept of independent experts, because the experts are being paid by the respective parties, they are not going to testify independently. But honestly, the same concept prevails in international arbitrations, and there, as an expert, our reputation has to be quite important. In case I'm not going to testify as an independent expert and I'm going to side with the party who's going to pay me, probably my reports and my testimony is going to be rejected by the tribunal. And once that happens, it's going to damage the party's case as well as my reputation. So therefore, we as experts, and generally all experts who are testifying, are quite independent, and they are there to help the tribunal. And definitely domestic arbitrations are seeing more and more of experts. But yes, unlike international arbitration, still a bit of reluctance is there, which I believe in coming few years will go away. Thank you, Prakash.
Thank you. So when it comes to expert witnesses, I remember a movie which was called as My Cousin Vinny. So in that movie, Vinny Gambioni is a lawyer who is defending an accused for murder charges. And all the evidences are against the accused, but Vinny's friend is an expert in automobile. So that expert gives a testimony in court that, these tracks cannot be of a particular model. And that's what became a game changer in that trial. But that is all movies. But taking to expert witnesses stages, would you share your experience in any of your arbitrations where appointment of an expert witness turned out to be a game changer in the matter, and which really helped clients and you to navigate the arbitration?
Frankly speaking, not in one case, but all cases, like every time we have an expert, it is a game changer, because expert play a very important role. And as Rohit said, no matter if it is a party appointed expert or a tribunal appointed expert, we can make out very easily in the cross examination if the expert is independent or not, and it loses the credibility, and it's of no use if the expert is not giving a genuine opinion. Of course, there could be difference of opinion, and that's where the expertise lies, because one person can see the same thing from a different perspective. But that doesn't matter. What it helps really the tribunal is coming to a right conclusion in a domain which is highly technical, and it requires a lot of experience in handling those issues. And tribunal may be trained legally, but it may not be trained technically to understand those aspects. There are a lot of nuances in construction industry. We did one arbitration in insurance sector where there are a lot of custom and trade usages which are there, and you need a person who has actually handled those kind of matters. And that person may not be a trained lawyer or an accountant, but just having a number of years of experience, it matters a lot for that person to come and testify before the tribunal. When you talk about personal experiences, as I said, we have many, but just to cite a few, we were doing one arbitration for drilling of the well, and the way the whole arbitration was dependent on whether the well was drilled to a particular depth in oil and gas. And when the drilling happens, if you hit a hard soil or a rock, then you have to drill sideways, and that is also calculated in the depth, because there is a minimum work program under the production sharing contract, and if you don't drill, then there are penalties which are very heavy, and you don't move to the next phase of exploration. And we got an expert. They knew exactly how the drilling happens and what are the different kinds of soil, and that really helped. It was really a game changer with the tribunal, with the help of demonstratives, and that really helps because the expert can show a video or a PowerPoint presentation and different kinds of aspects of drilling. It really helped for the tribunal to come to a correct conclusion. We of course won, but that doesn't matter. The process matters a lot in the arbitration, because if we can assist the tribunal in whatever way we can. And one thing which I want to emphasize is early engagement of an expert, because you get an expert at the evidence stage, you cannot change your pleadings. And if your pleadings are not supporting what the expert is saying, the tribunal finds it very difficult to grant the relief. Or you can't mold the relief depending on the expert's evidence, because many times you are fixing the expert testimony to your claims. Rather than that, what we should do is we should have the expert involved in the beginning, so that the claims are in consonance with the opinion which the expert may have at the end of the pleading stage and at in the evidence stage. So all these stages are very important. Of course, today is not the day for discussing all those aspects, but when it comes to expert evidence, the timing, selection of expert, and the manner in which the expert presents the opinion in a very simple form. Because many times what happens is you have a 1,000-page report, but you don't have an executive summary which summarizes in a very simple language. It's of no use. So in that sense, I feel that expert is always a game changer.
Yes, thank you so much. So as Rohit discussed that, in India, and especially when it comes to ad hoc arbitrations, expert witnesses, this trend is yet to kick in. So Gauhar, my question is to you is in context of an arbitration which we were doing, and when we filed an application for appointment of an expert witness for an expert to do a delay analysis, and the tribunal, did not take it well. Tribunal said that, we have expert, we will do it. Why do we need an expert? So do you think that this approach of tribunal, especially in domestic arbitration, needs to change? Because, for technical matters, we definitely need a person who can help the tribunal for assistance.
See, there is still some reluctance in tribunals, or as Rohit pointed out and even Tejas pointed out, there's some amount of reluctance in the parties as well as tribunals to go to experts for some strange reason. I'm not able to understand why. But the example that you gave, the case we did, and they did not appoint an expert. We knew what the result came. So, and we are witnesses to that. An expert not being brought in, and an expert not testifying on a particular aspect of a very complex matter, and the entire matter revolved around drilling of a tunnel, and an expert was not caught, and both the parties were arguing who drilled better, who could not drill better. The award that ultimately came in without expert opinion is a mess, according to me, and we will be doing whatever we have to. But in my view, the reluctance shown by the tribunals, one is due to there being a technical member on the tribunal panel, and second is they, of course, as Rohit pointed out, that there is some amount of feeling, or there is some amount of this idea that there can be a partiality on the part of an expert, and that brings the tribunal or the parties to a conclusion that they don't need an expert, but they are very important. And I am an advocate who always wants an expert prior to preparing even for the matter, because we want to also understand the technical aspects of the matter before we prepare the statement of claim or a statement of defense for that matter. Because we never know. We as lawyers, we can only understand what the clause is saying. We can interpret it in a particular manner. We know how SIAC will do the procedural part of it, and we will present the case. But ultimately, the expert is the person who will tell you what your client actually did, or what the other side actually, how the other side has not performed properly in terms of the contract and what they were supposed to do. So yes, I am an advocate for expert witnesses at the beginning of any process that has to go to ADR, not even arbitration, any process. If you want to conciliate, or you even want to mediate, you want to understand what really happened on the ground. And we are not experts. We hardly go to sites, and with pandemic and all, we really can't go and see what exactly is happening on the site. So experts really bring a lot on the table and really help in expediting the matters.
Thank you so much, Gauhar, for that insight. Now, this brings me to the topic, which is a matter of concern right now for everyone in every party, which is confidentiality. Because when the matter, as Tejas explained, that the moment matter goes to court, it is out in public. However, when the matter is still going in arbitration, there is a lot of extent that the confidentiality of parties can be protected. Now, my question is for Kevin, that in 2021, how important is the confidentiality for parties in context of SIAC, of course, and in general, when it comes to initiating an arbitration? Do parties really ask these questions, that what if the news will be out in public? Should we not choose to arbitrate just because this will become a news? Do you come across these kind of issues?
Yeah, we certainly do, and particularly in light of recent events, I probably get 50 emails a week on the status of cases that may be in court. When you're choosing an institution, to a certain degree, you're choosing the confidentiality provisions in that set of rules. We'll also see parties in the arbitration clause will bolster the confidentiality provisions, because under most sets of national legislation, as we were discussing during the presentation of the papers yesterday, you don't have a codification of confidentiality. It may be an implied duty of confidentiality. So under the SIAC rules, we arguably have the most robust set of confidentiality provisions, whereby even the existence of the proceedings are confidential. Singapore has also done well to enhance the tribunal's power to breach sanctions of confidentiality. You'll see from decisions in the Singapore courts as well that you will have proceedings that are sealed, so you will have anonymized decisions that are released. We find in Asia Pacific in particular, one of the fundamental advantages of arbitration, the confidentiality is very important to SIAC's users.
Thank you. So taking from that, Tejas, I have a question that, it's as Kevin explained, that when it comes to arbitrations, parties do adhere and institutions do adhere to confidentiality. But the moment the matter goes to court, suppose you have an award under SIAC rules, the moment you challenge that award and the moment the award is being enforced, say in India, then there is nothing confidential in it. So if parties is even going for an interim measures in Delhi High Court, then again, the whole confidential aspect is gone. So even though there is a section in the Arbitration Act 42A, but when it comes to disputes taking into the court, is it a myth? Or if that is true, then what can be done to to protect the confidentiality of parties?
So in 2019, we have introduced section 42A, which talks about confidentiality. Although the recommendation was also to disclose in any circumstances where you need to get an interim relief or challenge the award or enforce the award. But if the way the section has been worded now, it only creates an exception to the breach of confidentiality for enforcing the award. So there is some anomaly there, because if we want to go under section 9, there is obviously a breach of confidentiality, and also while challenging the award under section 34, again the award has to be relied upon in the court proceedings. The way we can avoid this is, as I was talking earlier about avoiding going to the court and going for institutional arbitration. As Kevin mentioned, the SIAC has a robust confidentiality obligations. Now you have 42A, which imposes confidentiality not on the parties, tribunal, and also the institution, but every player. For example, you have a third-party funder, then the confidentiality extends to those players as well, and also the tribunal secretaries or anybody who is involved in the arbitration. So the easiest way to avoid any breach of confidentiality is going to institutional arbitration. For interim relief, go to emergency arbitrator. But of course, once the award is passed, then of course we have to go to court, because only the courts have power to set aside the award or enforce the award. But at least till the award is passed, the confidentiality helps a lot, because the parties' rights are still to be decided. And that is where we have to really see that the parties don't go to court and try to resolve their entire process with the help of the institution. Even when you have institutional arbitration, you don't have to go under Section 11 for appointment of an arbitrator, because institutions will appoint the arbitrators. So that way, we have answer to all the issues with regard to confidential and institutional rules. The problem is only because we go for ad hoc arbitrations, we have to go to court for every step, and then the confidentiality is really a myth. So I agree with you. The answer lies in going for institutional arbitration and also using the tools to avoid going to court, because Section 5 of our Act also says that the intervention of court has to be limited to what is provided. And what is provided is also subject to the agreement between the parties. And if the parties go for institutional arbitration, then really they don't have to go to the court system. Anyways, our all court systems are overburdened. You don't get the consistency because the roster of the judges keep changing. And again, once you have the pleadings completed and all, it takes really long time. Some of my Section 9 applications are pending even beyond the award is passed. So it has become infructuous. But now we have, fortunately, an amendment to our Section 9, is that once the tribunal is constituted, the matter has to be referred to the tribunal. But by the time you have the tribunal constituted, the whole confidentiality, everybody knows about all the cases, big cases we have, because invariably this 42A is meaningless, because invariably people know what are the cases because either party is in the court. But that thing has to be changed, because if we think of any other jurisdiction like Singapore or London, we don't know what arbitrations are going on or what is happening in those matters, because these are all commercially confidential information which parties want to protect. They have business dealings, they have long-term relationship, and they don't want to spoil it, because that can affect, and mostly all the entities are also listed entities. So they have to disclose this to stock exchange also, but not the details of the proceedings. They can just mention about few aspects, but when you go to court, everything is public. So that should be avoided by using the mechanism of institutional arbitration.
So one thing is, like, do you agree that there can be a mechanism that where parties can redact the contents of the award, or maybe suppose a party is going to under a Section 9. So recently, if I take a cue from the case, is the Amazon future dispute. The arbitration proceedings are going in Singapore, but the matter came to court for enforcement of emergency award, and then it was out in the news that there's a dispute between the parties. Do you think that a mechanism can be adopted where only the question, a determination is before the court, and the names of the parties, the contents of the arbitral award, any sensitive information which can really harm the reputation of parties, or it can have a market effect, can be curbed? So do you think that that mechanism can be worked out in India?
Yes, certainly. If you, and in Singapore and other jurisdiction, you have cases which is A versus B and X versus Y and all that. But ultimately, what it matters is that we have a lot of courts, and it becomes very difficult for domestic arbitration to be kept confidential. Of course, in some cases, we can have institutions to support this, but in practice, it will be very difficult to have that kind of a mechanism. But definitely we should move towards that to protect the confidentiality between the parties. But if the parties are so concerned, there are ways and means. So one way is to change the mechanism, the other way is to use the institution. And I would suggest the easier approach is for the parties not to come to court. But whenever we have seen there is an Indian party, there is a tendency to go to court for every little thing. And that makes the confidentiality is just a notion which is not in real existence.
Thank you so much. Now, this brings us to the last topic of the discussion today, which is third-party litigation funding and contingency counsel fee arrangements in arbitrations and their legality and concerns. So my first question is for Rohit, that see, third-party litigation funding is again a norm in international arbitrations. Do you think that if this is more approached, this is more accepted in India, then the parties will have, a weak party may have the weapon to fight the big party, the big arbitrations, and they have a chance to succeed? Do you think that that can work out in India?
Yeah, so basically, you see, we practice as experts both internationally as well as in India. So internationally, almost close to around 75% of construction disputes, which is our area of expertise, are third-party funded. And unlike in India, where the concept of third-party funding is growing but has got some legal issues to it, which probably the other panelists which will be talking about. But definitely, I see third-party funding as a very big beneficial step, especially for for subcontractors, contractors who are taking up employers. Imagine a situation where a party is fighting a Fortune 500 employer which is setting up a huge oil and gas plant at the cost of billions of dollars, and the contract is probably for $50 million, and then that subcontractor or contractor wants to take the employer into arbitration. The employer is such a mammoth company. It's like a David versus Goliath kind of a fight. So unless you have got the money power supporting the contractor and subcontractor, which is generally the claimant, it becomes difficult for them to approach arbitration. And because the other side will probably deploy best of lawyers, best of experts, and so which becomes very difficult and impractical for the claimant, which are contractors and subcontractors. So I am a very strong supporter of third party funding. I understand that things are improving, but there are still some obstacles which needs to be sorted within India. But definitely, I see the future of third party funding quite strong, especially in construction disputes.
Taking from that, Gauhar, I have a next question for you. That in arbitrations, the disputes can be very long, complicated, voluminous, and you really need a manpower. So it's a very complicated arbitration which requires thousands of volume and a lot of lawyers. It requires a strong legal team, and we have seen it often that the parties lose out on a very crucial claim just because they don't really have the right counsels defending the arbitration. And of course, a good counsel means a very high fee. Now, contingency fee arrangements are a practice at some jurisdictions. However, it is barred under Indian law. But do you think that, suppose when it comes to arbitrations, if certain measures are taken where there is a contingency fee arrangements, then a weak party may also have the best of lawyers, and the best of lawyers will not have to really worry about the fee? And do you think that these arrangements can really work in India, and whether we should introduce?
See, I have a personal view on that. According to me, contingency will not work in India. I'll give you the reason for it. See, lawyers' involvement in a matter should be only a service, according to me. That's my personal view, as I said. And a lawyer, choosing a lawyer, getting a lawyer on board, and selecting a lawyer is the party's prerogative and responsibility. Now, if you hire or engage a lawyer who has no background in that particular field, and you are aware that they will not be able to handle your matter, then the litigant is also responsible to a very high extent. Having said that, if we bring in contingency into it, I don't think the quality of legal support or the quality of lawyers will increase. Rather, we will add one more problem, and I'm only talking about in the Indian scenario. When one additional interest will add that award can be beneficial for the lawyer as well, then I think there will be many problems that will come and get added to already existing problems that we have, which I would not want to name them, but we see that there can be some issues of some fraud being played, etc. On the other side, or somebody trying to do some arrangement somewhere. So I think a lawyer's service should always be kept separate. A lawyer's expertise has to be in their profession, and it should never be clubbed with the fee or the contingency as we're talking about. And they should never be bothered about the result. As Tejas rightly pointed out, we should prepare for the matter. We should present the best of our case to the best of our availability and knowledge. But we should leave the rest of it to the tribunal, and the result has to be borne by the party. So that's my personal view. Others may have different views on it. But so far as Indian scenario is concerned, contingency, according to me, is not a very, very feasible option.
Certainly, we really don't want to have that ambulance chaser practice in India going on. So, I thank you all the panelists. Now we will take some questions from the audience. Uh, if the RGN you guys can send any questions on the chat, then I can ask the panelist. I will just wait for the questions. Okay, so I have a question. The question is for Mr. Karia. Now, the question is that, it's about delay in arbitration proceedings. So the question is, do arbitrators really need to take care of how much cases they handle in India? Because usually what we have seen is that arbitrators take a lot of matters without seeing their case diary. So do you think that there has to be some provision where an arbitrator can handle there should be a capping of matters for an arbitrator for every year in terms of the Arbitration Act? Something of that can be introduced?
It's very difficult to put a cap on the number of matters, but of course, when the parties are selecting or the institutions are appointing, the arbitrator has to make a disclosure. So there is a now provision under the Act for making a disclosure with regard to the availability. And that is in Schedule 5, where they have to make the disclosure with regard to not only the independence and impartiality, but also the availability. And that is very important. For example, whenever ICC appoints an arbitrator, we have to share our calendar for next 1.5 or 2 years. And also same is with SIAC, when at the time of appointment, the institution asks you how many cases you are handling. Do you have the time and are you the available? And you have to make the commitment. Now, after making that commitment, if you don't fulfill, that impacts your future appointments. And that is where the flexibility should be kept between the parties and the arbitrator and the institutions. You can't just put a number of arbitrations cap in the Act itself, because many of those arbitrations may not be that active, or the parties may be taking time to settle their dispute. So that's not manageable. But what is manageable and what is advisable is to take the number of arbitrators from ongoing arbitrations from the arbitrator and ask the commitment for the availability. And having given that, then it will be very difficult for the arbitrator to say that I'm not available for such a long time. And institutions don't take it kindly if you are delaying just because of non-availability. I have seen it impacts the future availability, because the delay, even under 29A, there is a ground for replacing the arbitrators, and under Section 14 also you have an ability to go to court for replacement of an arbitrator if the arbitrator is either defect or de jure unable to perform their obligations. And one of them is timely adjudication, because the time is the essence in the arbitration. So either at the stage of 29A, or the institution or the parties can definitely approach the court if the tribunal is not giving the time. But the problem in India is that moment we are before the tribunal and they say we are not available, we don't object, because ultimately we have to get an award from the tribunal. But if there is an institution who is a watchdog playing a very important role, then it helps to control the time in terms of managing the time and also not exceeding the limits which are expected from the arbitrators.
Thank you so much. So I have a next question, which is for Kevin. So Kevin, recently, in light of the Amazon future disputes, there was an issue of emergency arbitrator, and the issue before the Delhi High Court was recognizing the concept of emergency arbitration. So do you really think that Arbitration Act in India needs to recognize the concept of emergency arbitration? So because SIAC has the emergency arbitrator provisions, and even if the award is passed, it becomes a deadlock in India in courts. So what's your view on that?
I think that we're all watching with great interest. What Singapore has done very well is they've included an emergency arbitrator within the definition of the arbitral tribunal. So it's not just the SIAC institutional rules on emergency arbitration that have really made it grown. It's the fact, as Tejas mentioned earlier, that in Singapore, for Singapore-seated arbitrations and foreign-seated arbitrations, these emergency arbitrator orders and awards are enforceable as though they're an order of the High Court. This has been a huge game changer for arbitration. It's allowed emergency arbitration really to flourish in Singapore. So we are watching with great interest on exactly how India is going to deal with this issue. I should say as well that the string of decisions in India, these are seminal cases that everyone around the world is watching, starting from HSBC, Raffles Design, Hotel Mumbai. These are all seminal emergency arbitration cases, which is why we're all waiting with such great anticipation on Amazon.
Thank you. Thank you. Gauhar, there's a last question from the audience for you that, 2020 has moved us all online and even the arbitrations are taking place online. So do you think that adaptability of technology will be the key trait of an arbitrator for the next decade?
Sorry, come again, Prakhar. Sorry, I
The
just
question is adaptability of technology will be the primary trait of an arbitrator for the next decade?
Okay, thank you. Prakhar, that's a very good question, very interesting also. See, adaptability is a part of general human behavior, and with times that we are seeing right now, one has to adapt to what we are doing. Other than arbitration as well, if you see courts that we are dealing with, even judges and very old practitioners, they are adapting to the latest technology. Now, this pandemic has shown us that how we can actually use the technology which was always available to us to the best of our use, and it requires very less expenditure. Someone sitting in Delhi can make an argument to a tribunal sitting in London without even traveling. So it is reducing the cost as well. So seeing from that perspective, yes, adaptability is very important. I have always maintained that an arbitrator has to be dynamic. Not only subject matter knowledge is important, but general awareness of what's happening around, and to be able to match up to that speed is very important, because they are ultimately what they're doing. They're just resolving an issue that a party is aggrieved by something. They have to resolve it. Now, if they're not equipped properly, suppose in a VC system, we have seen some practical examples where some of the arbitrators are not able to connect to the links that we provide, etc. It has delayed the process. So adaptability in that sense is very important, and an arbitrator has to really be dynamic, and they have to adapt to the latest technology and latest world that we are living in.
Thank you so much. I think we are right on time to end the expert panel discussion. I really want to thank all the panelists for taking out time today for this brainstorming session we had today. I'm sure that we'll really come to very positive and unique solutions in the near future to all the practical aspects. Thank you very much. And I'm really also thankful to all the students and the practitioners who have contributed so thoughtfully written research papers for all these themes. And I had gone through some of those papers, and I really liked some very unique solutions which students had presented. So now I think the moment which we all have been waiting for is the announcement of the prizes and the announcement of the winners of the research paper presentation competition. I would like members of RGNUL, RGNUL Financial and Mercantile Law Review to present and give the vote of thanks and just tell the names of the winners. Thank you so much.
Thank you, Prakhar sir, and all the esteemed panelists. It was a very pertinent discussion, and I'm very sure that we all obtained certain learning points about the practical aspects of arbitration and practice. So the results of the paper presentation session, which was conducted yesterday, was a very tough competition, and the marking became exceedingly difficult for us because we had to compute an aggregate score of the presentation as well as the manuscript that the participants had submitted. So with regards to the prize, and as a testament to how close the competition actually was, we had a tie for the very first position. So we had to compute and have a tiebreaker for that. And since we gave a greater weightage to the manuscript scores, the final results are now in. And the first position goes to Mr. Naman Devpura for his paper titled Third Party Funding in Arbitration, International Landscape and the Road Ahead for India. Naman is a student of Gujarat National Law University, Gandhinagar. As a reward for his first position entry, he shall be rewarded with an internship with Shardul Amachand Mangaldas and Co., as well as rupees 10,000 as prize. Second prize, which was essentially a tie, but we had to break down it into first and second prize. The second prize goes to the authors, Mr. Vivek Krishnani and Mr. Rajat Sinha, who are students of National Law University, Jodhpur, and their paper is titled Conflicts of Interest Planted by the Parties for Derailing Arbitral Proceedings. Since it was such a close competition, we are very grateful to Shardul Amachand Mangaldas and Co for granting an additional slot for them. So we also would like to congratulate the second entry authors on being rewarded with the internship with SAM and Co. They are also rewarded with free passes to Singapore International Arbitration Center Southeast Asian Academy, which is going to be held on 29th and 30th of July 2021. In furtherance, lastly but certainly not the least, the third prize goes to Bala Pragata M and Shreyas Kafle, who are students at Jindal Global Law School, Sonipat, and their paper was titled Assessing the Prospects of Ad Valorem Charges to Curb Inflated and Frivolous Claims in Arbitration. On obtaining the third position, they would also be awarded with free passes to SIAC's Southeast Asian Academy to be held on 29th and 30th of July. We sincerely appreciate the efforts of all the other participants as well, who took out their valuable time and made sincere efforts to submit certain submissions, which, as Prakhar sir also mentioned, presented very novel solutions to all of these problems that were enlisted. And we wish you all the best for your future endeavors as well. Lastly, on behalf of the entire editorial board of RGNUL Financial and Mercantile Law Review, I would like to extend a warm gratitude and thanks to all the esteemed panelists for this amazing discussion. Prakhar sir for your moderation. We would also like to thank Professor Dr. Anand Pawar for his constant support and encouragement. And Pawar sir, without your help and encouragement, none of these events would actually be possible. So we sincerely thank you for all your support. And also our Honorable Vice Chancellor, sir, Professor Dr. G.S. Bajpai, who took out his valuable time and gave the inaugural address. Lastly, we would like to thank all the attendees for patiently attending this event. And we have shared the feedback form in the chat box, and we would be very grateful if you could fill that.
Thank you so much, Stalin. And I again thank all the panelists. And really congratulations to all the winners for the paper presentation and the competition. And I would like the panelists to share their any good words for the students. We can start with Mr. Tejas Karia. Do you have anything to say for the students?
No, certainly. I'm very happy that the topics they have selected for paper presentation are also quite interesting. And I'm very curious to even if I get some time to read the papers of the first three winners, and because the topics are quite good, and we should continue with this. Prakhar, we should definitely work with RGNLU, and as Gauhar was saying, that we used to go and teach there. Because what I have learned and I have seen is that sharing practical experiences with the students is very important, and it matters a lot. And unless and until we share the practical aspects and nuances, theory is of not that relevance, because you need to give them that exposure. And the internship which they will have with us, they will see that. But as and when we get an opportunity, we should have these smaller discussions, or maybe webinar is now a very easy tool that we don't have to travel all the way, but we can still connect and be connected with them. So I want to wish them all the best in whatever field they choose, but arbitration is developing and has developed as a specialization for the law graduates, and they should definitely consider arbitration as their career in future once they become the full-fledged lawyers.
Thank you so much. Rohit, would you like to add something?
Yeah, so I'm quite glad to see the topics, which have been given the first three positions, and especially the first one being third-party funding, the road ahead and all. So I'm glad that students have gone and do in-depth research to understand the third-party funding concepts internationally and within India. I'm quite glad. Also, at this stage, I would like to add, one thing which me as a construction expert personally wants to say is that students should definitely explore the area of construction law, which is something which in India slightly, other than SAM probably and maybe one or two more law firms, you don't see that kind of expertise. Now that's a highly domain specialized legal area, but that's something which definitely I see is the need of today, especially India, the second largest industry in terms of contribution to GDP is infrastructure. So you see a lot of disputes and arbitrations related to construction industry being there. So construction law is an area which should definitely be seen by the students and by the youngsters. Thank you.
Thank you so much. Kevin, over to you. Any message for the students? You attended the yesterday's session as well, so what are your thoughts on everything?
Yeah, my thoughts are, is this is quite consistent with my experience in India, is that the students and young practitioners are amongst the best in the world. I think that it shows how you can have a voice in arbitration at any stage of your career. You can identify an issue, approach it with nuance, see the academic and practical implications, and be able to now communicate with the rest of the arbitration community. What I would say to the students, it's great to see you being involved early in your career, but arbitration is also a very long career. So you may have another 50 years in arbitration to be addressing these issues. So it was very heartening for me to see the quality of these papers.
Thanks a lot. Gauhar, you also judged the session yesterday where the students presented all these papers. How was your experience judging the students and giving novel and unique ideas to all these problems, and how was your whole experience?
I was really lucky to be seeing students picking up such topics. They were really complicated matters, and some matters where even we don't put our hands into. But these students at a younger age are getting into it. They're trying to read on it, and they're able to answer questions. So the best part was one can prepare anything, but when you ask a question, they were actually able to answer whatever questions were put by some expert, by Kevin or me. So that was really nice to see. As I've maintained that I've always found students at RGNUL very interested in the practical aspects of things, and that's very important for anybody who's going to join the profession to see what they actually are getting into, and getting it from industry experts like Kevin, Tejas, and Rohit. It's the best one can get. And we are really happy to be a part of this session, and we really wish all the best to everyone. And we will, of course, be connected, and we'll definitely find some time to come in the coming days to come to Patiala again and enjoy your hospitality also.
Thank you so much, Gauhar. So now I would like to thank the members of RGNUL Financial and Mercantile Law Review. So there's an anecdote to it. I was in college when this journal was started. It was started by my roommate, and it has come a very long way. And today you guys are organizing these events on such a large scale. And I really want to thank all the members because we had a very long brainstorming session while identifying these 6 topics. And I'm really thankful to Aditya and all the editors of the Law Review for managing and doing all the great efforts. And I think this event has been a very good success. And I really look forward to meet everyone next year again for the 2002 session. And thank you very much. Thank you, everyone. Thank you all.
Thank you.
Thank you.
Thank you.
Thank you.